Welcome to the BrandWise podcast, where we talk about the big branding moves that business owners are making and the why behind it. I'm your host, Jess Freeman, here to help you be wise and be bold. Very excited to be chatting with my friend Sarah today. We're going to be diving into trademarks and copyright and all that kind of fun stuff, because I know some of you, when you're rebranding and pivoting and like moving into new things, you're like, I want a trademark finally, like whether it's your business or I know some of you are like creating courses and programs and you're like, this is my signature program and I want to trademark it and that kind of thing. So I was like, okay, I got to bring Sarah on, talk about trademarks and clarify what's what and all that kind of stuff. So thank you so much for being here, Sarah.
Thank you for having me. Excited to be here today.
Yeah. So we're going to dive right in. I want to start with the basics because I know some people might be a little confused. I've seen some confusion online. Talk to us about the difference between trademark and copyright.
Yeah, absolutely. So it definitely is one of those questions that as a trademark attorney, I get all the time because it can be very confusing when you're a coach and running a business. What legal protection do I need? I know I need contracts, terms. Then what about copyright, trademark? So there's really an easy way that I like to think about it. And we'll start with copyright. Copyright law protects your content. And so I like to think of C and C. So copyright protects content. It's anything that you're creating, putting out into the world in a fixed form. So this might be an online course. It might be an ebook. It could be a social media post, a blog post, a picture, image. Basically anything that you are putting out into the world in fixed form is automatically protected by copyright law. And so that means that you own it. Nobody can take it, steal it, sell it without your permission. That's the law, right? But we know that especially on the internet, that doesn't always happen. And so when that happens, there are a couple things that people can do to secure their content. So one is they can send a cease and desist letter if they know that somebody is copying their content. Now, it does have to be like nearly word for word. You can get the website to try to take it down. This works especially well with photos and ebooks and things like that. And then you can, in the US and in most countries, register your copyright with the US government. And so what that allows you to do is then to sue for copyright infringement if somebody does steal your work. And, I only suggest doing that really if you meet two criteria. One is that whatever you're trying to protect is in final form. So your course is done. You're not making any changes to it. Your ebook is done, because if you register a copyright and then make a bunch of changes, you're nullifying your registration. So you want to make sure it's done, number one. And then number two, that you would actually go after someone for copyright infringement. Not everyone is going to take that step. And so those are just some things to keep in mind. On the other hand, we have trademarks, and trademarks protect brand names, logos, course names, signature coaching programs, retreats, podcast names, as well as any products that you might be selling, goods. In the health and wellness space, people might be selling exercise clothing or water bottles or white labeling supplements. Anything like that can be registered as a trademark. Anything that you're selling out in the marketplace. And trademarks are really, really powerful, and I would argue more so than having a copyright, because it allows you to own your brand name. And so as you're growing and trying to stand out in the marketplace, having a brand that you're known for, I'm sure you deal with this all the time with your clients, just what's your brand, what's your voice, like what do you want to be known for? Having a registered trademark allows you to know that is secure. Know that whatever you're naming your business, your programs, your podcast, nobody else can take that away from you if you own it. So having a registered trademark is an offensive play, because if you have the trademark, it means nobody else can. And, registering a trademark, it is quite a long process. It can take this, it can take anywhere from 9 months to a year. And that's if everything goes well, which it doesn't always, right? And, this is something that is a big time, money investment. So you want to make sure that you're really invested in that brand.
Mm-hmm. Yeah, it did. I was so surprised with how long the trademark process was going to take. Now, my first trademark took like 18 months almost, maybe even 20, if I remember correctly. So it was much longer. The podcast trademark, I think, was less than a year. Yeah. It was like 8 months or something like that.
It really has slowed down, interestingly, since COVID. I think for two reasons. One is we all know that during that time, tons more online businesses started and businesses wanted to get trademarks. But the good news is the date of filing your application actually starts your legal protection. So if we had a similar trademark and I filed tomorrow and you filed 3 days from now, USPTO wouldn't even look at yours until mine was processed. So someone can rest assured that, once they file, that there is some legal protection there.
Yeah, that's the nice part, that it's like as soon as you file. And so sometimes it's kind of a race of who's filing first.
It is. And I get this question a lot. Interestingly, just last week, someone thought they couldn't trademark because there was a restaurant in Texas with the same name, even though they were like a fitness business in Nevada. And so a lot of people don't realize you can have the same trademark in different classes of goods or services. This is why it's always, great to work with an attorney to figure these things out. So a restaurant wouldn't conflict with a health coaching service, just similar to how we have Dove soap and Dove chocolate. Those are both registered trademarks, but they're not likely to be confused with each other, right? If I said after lunch I had the best piece of Dove, like, you would know, hopefully, that I wasn't eating soap. And so we can have trademarks exist within different classes of goods or services.
How much differentiation does there have to be within the different class and services? So for example, I know somebody who wants to trademark her name, her business name, and she's in the nutrition space, but she knows of an app that is also in the nutrition space that has that name trademarked. And I'm like, they're both in the health space, but one is a one-to-one business and one is an app. So is that considered different or not?
No, that would likely be considered too close.
Yeah.
So if she was in the nutrition space and then someone else had an business app, right? So it's not the fact that it's the app, it's the fact that it's in the same realm of industry. And so unfortunately, that is probably too close. Interestingly, trademark law is a very gray area. And so there isn't a black or white rule because the USPTO is made up of individual attorneys. And so, one guy could be upset at his cup of coffee and decide that this trademark is not going to go. And the next day he's happy and it's all fine. But what they're looking for is, would a consumer, if they came across these two brands, would they think that they're from the same company, right? So if I'm walking down the street with a cup that's white with a green circle, you know that I went to Starbucks. If I had gone to Dunkin' Donuts and got the same cup, that would be very confusing. And so they're not allowed to do that, right? That would cause too much market confusion. And that's why these things exist. Now, if your friend is doing nutrition coaching, focusing specifically on, hormones or something, and this app is bodybuilding for men, you have more of an argument there, because what they do, in the office, they're looking at, well, do these names sound the same? Do they look the same? Is there the same commercial impression? And then do they have similar services? And so you can argue that, my audience is just women in their 40s and this audience is men in their 20s. There's no way these are going to be confused. And, this is why it's helpful that you want to have an attorney, because we can make legal arguments to that effect. Like, here's this case law, here's where this similar situation happened, and the court found that it wasn't similar. And so that's when that comes in. Anytime you run into those sorts of issues, you're delaying your application for sure. And that's going to extend it probably past a year and a half.
Yeah, that makes sense. Okay. I like that explanation of like how to differentiate, because it is kind of sometimes a gray area of like, well, is there overlap or not?
It's a real thing, and another thing that people run into in our industry is some people might get a trademark infringement or cease and desist letter from someone saying that they're infringing on their trademark, and they'll come to me and be like, these are not even similar names. And so some people try to take advantage of having the trademark and try to get rid of anyone with anything similar, even if it wouldn't fly. So again, this is when you want to, get in touch with an attorney and be like, is this legit? Like before you make any branding decisions or things like that. And, one of the biggest questions I get is just, when is it time to trademark? Like, how do you know I just started business or I've been in business for 5 years? And it's definitely not a timing thing, because you can trademark anytime, even before you're actually selling something. So some people will file what's called an intent to use application, where they are reserving the name for future use. The Kardashians are big fans of this. They have like hundreds of trademarks for future makeup lines, and Amazon has, 800 trademarks. A lot of them they're not even selling yet. And so if you have this amazing course or program or brand name that you love so much, but you're not selling it yet, you can go ahead and start the trademark process anytime. Sarah Blakely, for her new Sneaks line, started the process a year and a half before it ever came to market. So, it's not really a timing issue. It's more of an emotional, how much do I love this name issue? And so I like to use something called the gut punch test. And that is, if you're thinking of your brand name, your business name, your podcast, whatever name, think of it in your head. If you got an email tomorrow with a cease and desist letter saying you had to rebrand in 10 days, how would you feel? And so if you get a gut punch, like, oh, I love this name, I've already invested thousands and years and all of that, it would be, a big gut punch. It's time to trademark. If on the other hand, you're like, meh, I'll just go back to ChatGPT and brainstorm some more, then it's not. Because again, it is that time and investment that you want to make sure.
Yeah.
But that gut punch test, a lot of people, when I tell them that, they're like, oh my gosh, yes, it's time to trademark.
Mm-hmm. Yeah, that is a good test. And that's part of why I finally trademarked. And I was like, I should have done this forever ago. So when I trademarked Just Creatives. Now, going back to the trademark with the intent to use, like what the Kardashians do in Amazon, I'm curious, and this may be like a super like complex answer, but let's say I like file this trademark because I'm like, oh, I love this name for my like course, program, whatever, but then I file it, I get it. But what if then like a year from now, I get after the trademark, I'm like, well, actually, I don't want to use this name for my course. I want to use it for my podcast, or like or maybe my whole business, like not just the course. Does that, like, do I need to refile the trademark? Does it still apply? Obviously, it kind of depends on like what kind of switch you're making, but how does that work?
Yeah, that's a great question. So if it is something completely different, so if you tried to register for branding services and then decided to do a podcast, you would have to refile a new application. You cannot add classes of goods or services on after you file. And so with intent to use, I always suggest at that point going as broad as possible. Any potential use you think you might have in the next 1 to 3 years of that, because what you can do is take away at a later date and then have what you have left. So I would say, well, Jess, what are you thinking? And you said, well, maybe I want a course, I might want a podcast, maybe I want an online shop. And I'm like, okay, like, let's just do all of that. And then a year from now, when it gets approved, you get issued what's called a notice of allowance. And at that point, you have 6 months to show that, okay, now I am using it, I'm selling it, here's the website, whatever, we can say, okay, well, you do have the podcast and you do have the branding, but you dropped the online store. So then we just eliminate that. And then it goes on to register with those two classes. So, it's better at the beginning to go wider, because what you can't do is go wider later, but you can narrow.
Yeah. Okay, so you said once we get it, then we have 6 months to then basically start using or like proving that we're using this trademark?
Yes. And actually you have 36 months. So you have 6 months, and then, well, the caveat is every 6 months you have to either file to show that you're using it or pay a fee. And so you can keep paying. It's a small fee. It's like $125, but you can keep paying that fee every 6 months for up to 36 months. I've had clients that, thought they really wanted it, put a product in development, and then we went through, 3 or 4 of the 6-month cycles. And then they're like, I don't think I'm actually ever going to sell this. And then we just, you drop it. That's the risk you take. You don't know always what direction your business is going to go in. It's happened to me. I filed a trademark for contracts and cocktails, and I thought I would be doing some events and stuff under that name, which I still love the name. But then my business kind of went in a different direction, and so I just let it expire. And, it's not the end of the world, but it does happen.
Yeah. I'm very curious now, how much the Kardashians are paying in these types of fees. Because if they have so many of these intent to use, I don't even follow the Kardashians, but I'm like, how much are they paying?
I mean, hundreds of thousands of dollars a year, for sure. I mean, most of that is probably in their attorney's fees,
right?
Because those fees are not big. But yes, they're managing a huge portfolio of trademarks. Yeah. But it's worth it to their business to have that flexibility, to know that, they've trademarked their kids' names, it's a fascinating case of IP for sure.
Yeah. I'm curious what your opinion, if you think there's anything specifically outside of our business names that you're like, I think every business owner should be trademarking this.
So I think podcast, because, a lot of businesses put so much time and energy in the podcast name. Let's say you have 3 years of episodes and someone comes along and trademarks. Now you have to go back and change all of those names, all of those links, a whole big thing. So I definitely think podcast names. And then the other big one is signature courses, because if you're selling this course over and over again, if you think about Marie Forleo's B School, and if you think about, Amy Porterfield and all of her course, all of those are trademarked, because you don't want to put all this money, time, energy, marketing, ad spend into a course name, run it for a little bit, and then have to change it after you've made all of those assets, recorded all of those modules under that name, right? What a pain to have to go back and change and re-record all of that. So I would say those are the top 3.
Yeah. I didn't really think about when you were talking about the podcast, and I was like, yeah, you have to change your podcast name and whatever. And then I was like, I didn't even think about the fact that you'd have to go back to every show notes if you mention the brand name in there, or the podcast name, I should say. But then all the show notes in iTunes, but then also probably every blog post if you're someone who puts them as blog posts on you. And I was like,
it's a lot.
Oh.
And, this is why before you launch a podcast or, name your course, you need to do a little due diligence. And this is not ChatGPT due diligence, because ChatGPT is not checking the trademark registration. So there are really 3 different things I suggest. One is to just Google the name and see who else is using it. And if they are in your industry and they have the R with the circle, that means they've likely registered the trademark, and there's a way to double check that. If you just see the TM, you don't know what that means, because there's really no legal significance to the TM. It means someone could be trademarking, they could be intending to trademark, or they're just slapping it on there, which I see a lot of that happening. So Google, see who else is using it. Check social media. Number 2, just see what, are there handles? Is someone using it a lot? Is there already a podcast name for it? And then finally, number 3, you can go to uspto.gov and they have a public search engine where you can actually type in the name and see what other registered and pending trademarks there are. Now, this is the point where if you're serious, you definitely want to get in touch with a trademark attorney, because it doesn't necessarily, it could be an issue even if it's not an exact match. If it's close, or if words are inverted or backwards or similar spellings, it could still be an issue that you are not able to move forward. So, there's just nuances there. So once you decide on a name and you love it and you're going to start investing marketing, branding dollars in it, you want to get in touch with an attorney. I had a client a couple of years ago who developed this whole new signature framework. She bought all the domains, she designed a thing, and then she was like, okay, now I'm going to go trademark. And it was like, we couldn't get it. And she wasn't willing to not have the trademark because she was building a whole certification around this. And so she knew that she needed that. So at that point she had basically had to start over. She came up with a new name that she knew she could trademark. And at that point, then put all those dollars. But she learned a very valuable lesson at that point of when you need to get this done.
Yeah. I'm curious if you remember her not being able to trademark. Was that because it was already taken, or was it, I know sometimes I've heard you can't trademark this, or my trademark got rejected because it was too broad or too generic.
Yeah, so it was not that issue. That one is more something we can work with depending on what it is. But hers was, there was something too similar. It wasn't the exact, it was the exact name, but a similar service. It was just too close. Yeah. And so, we came up with something better. When it comes to descriptive and too general, it really is a gray line. I've gotten trademarks through that seem very descriptive. The Fertility Coach Academy is one of my clients. She runs that. That's descriptive. We got it through. But then there's other ones that haven't. So, a lot of people don't realize also there's actually 2 registries within the trademark office, the principal registry and supplemental. The principal is reserved for the most unique names. It has kind of the strongest protections. Then the supplemental is where you can get on with more of these descriptive generic names. You still own it. You still get the R. You can still stop others. It's just considered not as strong as the principal. And so that's one tactic that clients can take, especially in our space where, most of us aren't billion-dollar companies, where this is the end all and be all, and being on the supplemental is just fine.
Yeah. I thought of you the other day. I made a little funny post on Threads, and I put the TM on something just as a joke. And but it made me think of you, because I was like, this isn't actually a trademark. And I'm not even trying to act like it is, but it was just I don't want it. I mean, in a way I was kind of I want this name, but it's also it's not actually going to mean anything. But I see that where people are oh, I'm just putting TM, and I usually see it as a joke, something funny, oh, I'm a lazy person, TM, or whatever, they just make it as a funny kind of thing.
Yeah, I also see a lot of people just overusing it in terms of programs and stuff that they are thinking about, or phrases that they just like and are using. I think a big thing that people don't realize is that to register a trademark, it has to be tied to something that you're selling or marketing or that kind of thing. It can't just be here's a phrase I came up with, or this is the name of my free Facebook group, or things like that.
Yeah. Can you also talk about, I don't know if people realize that with trademarks, there's follow-up and things you have to do years after having a trademark.
Yeah, absolutely. So there's a couple things that you need to do to make sure your trademark stays current. So one is you have to renew the trademark at between the 5th and 6th year after registration, and then between the 9th and 10th year, and then after that, every 10 years. And basically, you just need to show that you're still selling what you said you're selling, and that the trademark is active and current and all of that. So that's one big important piece. If you don't file that renewal trademark, or that trademark renewal paperwork, the USPTO will cancel your trademark and somebody else can refile.
Mm.
And this happened to one of my clients. We do our best to reach out to our clients and let them know these deadlines. And, we don't always hear back. And so one of my clients, their trademark abandoned. And so then they came to me in a panic, like, what do we do? And so we actually were able to refile and get it again. But that was very lucky, right? Because in that meantime, someone else could have trademarked it. So doing the paperwork. The other thing that it's on, the trademark holder's onus to do is to police the trademark. And so what that means is if you're seeing other people in your industry use your trademark or something similar, it's your job to stop them. It's your job to send it a cease and desist. It's your job, if you need to hire an attorney, to make sure that your mark is being protected. Because if you don't, it could become what we call watered down. And all of a sudden, everyone is using it. And so this has actually happened. There's some big case studies about this. One is Kleenex. Like, Kleenex is actually a trademark for tissue. But now everyone just uses the word Kleenex for tissue, right? And so it got out of control to the fact where they really couldn't stop it. I think Xerox machine is another one where that was a specific trademark and people just use it for the word copier. And so the trademark can become weakened, diluted, all of that kind of stuff. So if you see, someone in your space using something that you already have, then it's your job to stop them. And, you can start with a nice email like, hey, I noticed this, this is my registered trademark. Here's the certificate. Here's the number. You need to change within the next couple of weeks. Typically that will work because there's really no argument. Unless the only gray area here would be if the name isn't exactly the same and it's somewhat similar and you're trying to be like, this is too close. And so that's when you want to, reach out to an attorney too, to be like, is this okay? Or should I challenge this? And then if they don't, you can always send a cease and desist letter. Eventually you could file for, trademark infringement. So there's definitely things you can do, but you just want to keep an eye out for that. It's also why, especially in the online space, you want to think of the most unique names that you can, right?
Yeah.
There's a lot of accelerators, there's a lot of collectives, so add words around that, just make it as unique as you can. Those are the best trademarks.
Yeah, that makes sense. It's hard. It's hard to come up with.
It is very hard. It is, it's fun, but it's hard. I agree.
Yeah. Well, this has been so good and so helpful. I want to make sure that people can get in touch with you for trademark help, resources. I know you also have policies and contracts and templates. So tell us where we can find all the things.
Yeah, absolutely. So for any trademark services, my law firm is called Twist Law. And so that's just twistlaw.co. And then you're right. I have a full template shop at Destination Legal where we specialize in contracts and templates for coaches, health coaches, online business providers. That could be a whole nother episode, just the importance of making sure you have your coaching contract in place, all your website policies in place. I'm sure you get questions about that. So that's destinationlegal.com. We have a free coaches checklist on the 4 most important contracts and terms that you need to think about. And then I'm also starting a new program this summer, which I'm really excited about, called The Legit Coach, which is going to be specifically for coaches. And, it's going to be all encompassing and amazing. So the best place for that is just to follow thelegit.coach on Instagram. Everything is going to be there. I'm going to be doing some live workshops, and it's really going to be about helping coaches not only get those contracts in place, but also teaching how to think about the issues that are really impacting them. What if someone does steal my course? How do I think about, trademarking? What if what if my client ghosts me? Or what if, there's a chargeback? So all of those kind of legal things that are gnawing at us, it's going to be, how can you step into your power so that you feel confident in managing those sorts of things that inevitably will come up at some point.
Yes. Okay, awesome. I will link to that in the show notes so you guys can go find everything that she just mentioned. But thank you again for being here.
Yeah, thank you so much for having me.
Are you a squiggle or a square? Go to justcreatives.com/quiz to find out where your brand ends up and find out what a square or squiggle even means. If you enjoyed today's show, be sure to leave a review or share it on Instagram, and tune in next week for another episode.